All right, Brent Norling
Xinan, Zhang.
from Norling Law, specialist litigation practice based in Albany. We're here to talk about shareholder disputes and a little known provision in the Companies Act that we often leverage with our clients to help get a better result.
Yeah.
So we often see shareholder disputes,
Yeah, we do, heaps of them.
and a pattern that I see is often people are in the trenches when there's no money in the bank. As soon as there's some money in the bank, there's disputes around, what's fair. I do more work, I get more clients, therefore I should get more money. And so these disputes can fester, 12 months, 24 months. That's usually when they get into our office. That can result in a deadlock. Often it results in one person making all of the business decisions to the exclusion of another. We often act on both sides of that coin, and it can be very toxic. So what's a traditional approach to resolving those disputes?
So I think the traditional approach is, if sometimes you'll have a shareholders agreement. If you do, really good. If you don't, then that's what this video is about. So if you have a shareholders agreement, generally, the mechanisms in there would be a buyout or some sort of mediation or arbitration sort of thing, where the people would seek to come to an agreed settlement where one party would buy the other one out, part the relationship, or agree on a way forward.
And there's often a provision in there that just is a party-to-party negotiation as a first instance. And how do you think those usually go in these situations?
Look, I think it really depends on the people. Sometimes, when it gets down to that point, just like you mentioned a minute ago, Brent, that the people have really experienced a breakdown of trust. It's really hard just to get them even at the table talking, and forcing them, if they're unwilling in the first instance, forcing them there anyway is not going to help, is it? There's often we see there's so much animosity that they're just not going to be able to come to a sensible agreement on the way forward. And also, sometimes you've got people who are, we see people who are sensible, but and reasonable, but they've got very firm views as to price. There's a lot of emotional baggage, frankly.
And some people, if they're the majority shareholder, they will just take a real bullish approach of saying, hey, go sell your shares. Go sell your shares. See what the market's going to pay in a tightly held company. And it's a complete bluff, because obviously nobody's going to buy 20-30% in a company. They have no right to appoint a director, and it's left at the whim of a director that they have no relationship with.
And essentially what you're asking the public to do is to buy into a relationship. Of a failed relationship.
Because going into partnership, going into a shareholding is it's like a marriage. You need trust. And you would be buying in a situation where there has been no trust and there has been a dispute in the past. It's not that attractive.
I mean, I think sometimes it might work, and good luck to people that can get that. But
So, an alternative is this little known section in the Companies Act, Section 174. And so, it is a section that we leverage fairly regularly in these kind of very toxic situations, and that allows a prejudiced shareholder or a pressed shareholder to go to the court and ask for certain relief. There's some wrecking ball options in there. You can go to the court. You can ask for a liquidation or receivership. It's not something the court likes to do, because it does destroy a business. So we don't usually recommend those options. But there are other options, such as, if you're a 20, 30, 40% shareholder, even 50, you can go to the court and say, I want a mandatory buy or sell of these shares, and that's usually the order that we seek. And that allows a shareholder to go to court and say, I want out, and this is fair value, and I want the other shareholder to pay. Or it could be, I want him out, and I'll buy his shares at fair value.
Because the court has very, very wide discretion under that Section 174. So as long as you've passed the test, the first hurdle, so you've shown that there's oppressive, unfairly prejudicial, or unfairly discriminatory conduct. So long as you've shown that, essentially the orders the court can make are very broad.
Yeah.
And it's not conduct which has about to happen. It also covers conduct which has happened, may happen, or about to happen. So if you're stuck in a situation where you fear or you have a suspicion that, because of how we're going, some very bad things are going to happen in the future, you can come into that section. And I think, you're absolutely, usually you want to part ways.
And that's because most of the time the cases that we deal with, it's gotten very toxic. It's gotten to the end of the road for that relationship.
Yeah.
But if it hasn't, and it's not too late, you can go there and get orders to just regulate the affairs of the company.
Yeah.
We've been involved in a case where there was suspicions around misappropriating money, and it was a business that relied on lots of cash coming through it too.
Trust.
And so the orders that we ended up getting was just to regulate the affairs of the company, so there were proper processes in place that mitigated that risk. And so there's all sorts of options under that section. But what is prejudice?
Look, prejudice is, like I said, very, very, very broad. Could mean that you're essentially just you're blocking the other side from passing any resolutions. You're not entering into contracts or making the correct business decisions that you should be making.
An extreme example would be, major transactions without shareholder consent.
Yeah.
And then, less extreme.
Or paying or taking out money unequally, so paying yourself a dividend and leaving the other person dry.
Yeah. Or because there's a dispute, and you've had a dividend policy for many, many years, and then now there's a dispute, and now you're saying, actually, we're not going to issue dividends this year, and you get into deadlock where the company just accumulates cash to the detriment of the shareholders when it really doesn't need to.
Yeah.
Yeah. So I suppose, our message is actually just very simple. It's be aware of all of your options, educate yourselves, make sure that you know the rights, you know your obligations, and you can pursue the best possible option to resolve a dispute.
Absolutely.
Yeah.
Because at the end of the day, if you don't have all the information, how can you make the best strategy?
Because that's what we see most of the time is people formulating strategies without all of the options on the table.
Yeah.
And it can result in people selling or buying shares at ridiculous prices because they weren't aware of the court's ability to say, hey, here's fair price and it must be bought or sold at that price. Yeah. All right. Got any questions? Drop them in the comments below. Cheers.